But today we're really delighted to have Harwell Wells speaking to us. Let me very briefly introduce him. Many of you know him. Harwell is the I. Herman Stern Professor of Law at Temple. He teaches courses in corporations and legal history. In fact, he has a JD and a PhD in history. I think the JD from Vanderbilt and the PhD from UVA, if I remember, Harwell. Very well qualified to speak on these topics. I think Harwell's going to talk for roughly 25-30 minutes, give or take. And then we thought we would have an opportunity for questions afterwards if you guys have questions. If it's up to me, I would ask you to please ask the questions orally as opposed to putting them in the chat. I always find it's difficult to both speak and monitor the chat at the same time. So I think that Katie might mute you for now, although I don't know that that's necessary, but you'll have plenty of opportunity to ask questions afterwards. And as I say, I think that's preferable to putting them into the chat. I think we're recording this, and I think I'm supposed to let people know that. So this is being recorded. And with that, Harwell, I'll turn the floor over to you, if that makes sense.
Thank you so much, Arthur, and thanks to everybody for tuning in. This is a project, by the way, I do have PowerPoint, so I'll put them up in just a second. This is one of those projects, however, I don't know how other people arrive at projects, but sometimes you choose a project and sometimes something catches out of the corner of your eye and you start pursuing it and you discover there's more of a story there than you expected. And this project, the story of Peck v. Greyhound, falls into the second category, where I was originally just curious about an early 1950s case and I didn't know much about it. And I pulled a thread and discovered as I dived into it that there was much more of a story to be told. So let me get PowerPoints up and I hope everybody can see those. This was prepared for a symposium which I organized on the corporation religion, and there's something of a religious connection, but not too much of it. But it'll appear shortly in the Seattle University Law Review. And while I started with just curiosity about a case I didn't understand very well, I was pleased to discover that what I wound up with was an opportunity to connect two strands of history that rarely cross over, and that, if we're going to be honest, people don't think all that often of crossing over, which was the history of the civil rights movement and the history of corporation and securities laws. Occasionally over the past couple of decades, individuals kind of crying in the wilderness have pointed out that there actually are connections to be made between the history of the civil rights movement and more generally the history and structure of racial relations in America and corporation and securities laws. I want to point particularly to Richard Brooks's wonderful 2006 article. I think it's called The Race of the Corporation, but these individual articles tend to appear and they're really wonderful, and then nothing followed on from them. And I'm very pleased to say that in the last 2 or 3 years, for the first time, there seems to be a critical mass of individuals working in this field. Lisa Fairfax working in gender, Sarah Hahn, Evelyn Atkinson out at the University of Chicago, so that while we are still in the early days, I actually do believe there is a fresh wave of scholarship coming out about the intersection of corporation and securities laws and America's tangled racial history. So Peck v. Greyhound. When we've talked about it in the past, it's generally been buried in a footnote as the first social issues shareholder proposal. And I will explain what that is in a few minutes. But as you get into the history, you suddenly discover it's also very much a story of the civil rights movement involving organizations that at least you would have heard about, such as the Congress of Racial Equality and the famous individuals like Bayard Rustin. But there's also a very different story here, one involving state corporation law, the Federal Securities Acts, and the Securities and Exchange Commission. Two different strands leave me asking, where do I begin the story? I think I'll begin with our protagonists, James Peck and Bayard Rustin. Rustin on the right, some of you probably know about certainly Rustin, but I'll give a quick history. Rustin was one of the great civil rights leaders of the 20th century. Raised in Westchester, Pennsylvania, just outside of Philadelphia. He became a committed Quaker at an early age. Quickly got involved in both civil rights and anti-war organizations. Served a term in prison during World War II for refusing to be a conscientious objector. By the 1950s, became a major advisor to Martin Luther King. organized the March on Washington in the early 1960s, and ended his life in the 1980s as a somewhat reluctant icon of gay liberation, an extraordinary individual, as was James Peck on the left, on my left, I think it must be on your left as well, who is another one of those odd American radicals who seems to show up almost everywhere. A graduate of Lawrenceville and Harvard, got involved in labor radicalism in the 1930s, drifted into pacifism, also served a prison term in World War II for conscientious objection, then got involved in the Congress of Racial Equality, and you can follow his career until the 1980s. Towards the end of his life, he was protesting against atomic power. But their individual activism in the 30s and 40s took place within organizations. And the organizations were the Fellowship of Reconciliation and the Congress of Racial Equality, CORE. FOR, the fellowship, was formed in 1915 as an anti-war organization opposing the First World War. It still exists, and its main purpose is still anti-militarist and anti-war activism. Historically, it's extraordinarily significant because the Fellowship of Reconciliation, FOR, imported Gandhian nonviolence into the United States in the 1930s. The US had a pacifist tradition before that, but Gandhi really sought, to simplify enormously, pacifism not only as a personal choice, that is, one disassociating oneself from the machinery of war, but as a way to actively cause social change. And we're familiar with it, of course, from this Gandhian pacifism because it was adopted by Dr. King in the 1950s. By the early 1940s, many members of CORE were not only deeply connected to the anti-militarism and the opposition to World War II, but also committed to racial equality. But FOR didn't seem to be an ideal vehicle for pursuing civil rights and racial organization, especially because the fellowship was involved in trying to help conscientious objectors during World War II. So several individuals formed the Congress of Racial Equality. By the way, the first idea was to call it the Congress for Racial Equality, but then they decided racial equality was already a reality, so it shouldn't be a Congress for that. So it was organized in 1942, and during the 1940s, CORE organized some of the earliest sit-in protests. They borrowed the term sit-in from the labor movement. And it's really striking because what CORE did here, and you'll actually play a part in the story I'm telling, was not only protest in certain ways against racial segregation and racial hierarchy, they protested in a way that aimed to dramatize moral action. I've got a nice quote here: rehearsing, staging, casting, and replaying moral action as both ritual and spectacle. They wanted to protest racial discrimination. They wanted to dramatize it, so they got media coverage for their protests. And in the course of their protests, they also wanted to upend the hierarchies that were implied by racial protests. 1947, CORE and FOR organized something called the Journey of Reconciliation. Here are some of the individuals who wrote on it. Where does this come from? In 1946, in a case that's kind of overshadowed, largely forgotten, Morgan v. Virginia, the US Supreme Court banned laws imposing segregation on interstate bus transport, not, of course, within the state. This was actually a dormant commerce clause argument. What happened after Morgan v. Virginia was handed down? Nothing. The bus lines kept segregating it. Many southern states and localities kept enforcing laws against, or enforcing laws requiring segregation on bus transport, even when the transport was interstate. So Peck, Rustin, and 14 other individuals in the fellowship, whites and African American, decided to ride segregated buses through the Upper South. They would get on a bus in Washington, ride the bus lines at this point being Greyhound and Trailways, the main interstate bus lines, through Virginia, North Carolina, Tennessee, and Kentucky, and eventually return to Washington. Why was it 16 men? Because they were afraid that if they had women ride along, that would be a spark for violence, gender mixing. The issue of gender combined with race was inflammatory. Why did they not go through the Deep South? Because they thought they might get killed. So they went on the journey of reconciliation. And one way they were dramatizing, keep in mind that, of course, they were attempting to get publicity for their campaign. So not only was it the campaign we might understand with African Americans sitting in seats traditionally reserved or set aside for whites, which obviously happened in Montgomery a few years later, It was also white riders in the journey, insisting on sitting in seats reserved for African Americans. And what was most frustrating, apparently, for many of the Southern observers, white and black men sitting next to one another and refusing to segregate at all. The journey of reconciliation indeed occurred. They rode through the 4 states I discussed. The riders were threatened, arrested, and beaten on their rides. Rustin ended up being sentenced to a month on a chain gang in North Carolina, which he served in 1949. It didn't have a great deal of effect at the time. It's very strange to remember, but I think in 1947, certainly most of the national media that was white didn't recognize civil rights as the enormous issue that it would quickly become. By the way, in 1961, the journey of reconciliation was repeated as the Freedom Rides, which did garner a huge amount of publicity. James Peck was the only person who was on both the 1947 and 1961 rides. And this is what happened to the Freedom Ride bus in Northern Alabama. But before they went on, James Peck and Bayard Rustin left on the journey of reconciliation in 1947. They did something else radical. They each went out and bought 1 share of Greyhound Bus Corporation. 2 things. First of all, I have to say this. I don't know why it occurred to them to each go buy a share of Greyhound. It eventually became a spark for the protest movement I talk about in this article, but it's not clear to me how it crossed their mind that this would be another vehicle for civil rights activism. I should also say that in order to explain why buying a share is important, I now have to move from the civil rights movement to a less exciting area of the law, which is the history of corporation law, as important as it is. So let's think about shareholding in the United States, because of course, Peck and Rustin wanted to use their place as shareholders to influence the Greyhound Corporation. The United States has always had corporations, and since the early 19th century, it's always had business corporations. Business corporations have always had shareholders. In the 19th century, a lot of power rested with shareholders. Corporations were relatively small and had relatively low numbers of shareholders, at the most, say, a few hundred. Especially because a corporation would tend to be located in one area, that meant most shareholders could attend an annual meeting, where today we still have annual meetings to elect directors. So 19th century corporation law imagined shareholder meetings as deliberative bodies, the fonts of all the power in the corporation, the place where shareholders would go and debate corporate policies before electing individuals to the board being the body that actually oversees and runs the corporation. But corporations grew enormous by the early 20th century. This idea of the shareholder meeting as a deliberative body fell out of favor and indeed became seen by many people as kind of absurd. When AT&T has 500,000 shareholders, each of whom own only a tiny slice of the corporation, those individuals lack the economic incentive to go to the corporate annual meeting. And power in the corporation, as A.A. Burley and Gardner Means teaches us, was transferred to managers. So the separation of ownership and control. By the 1930s, it was almost a joke, the idea that shareholders would have any power within the corporation. But shareholders still had a role to play, especially there needed to be a quorum of shareholders' votes represented at an annual meeting. So machinery, legal machinery, grew up to get votes from shareholders, get their proxies, the right to cast a shareholder's vote at the meeting. And by the 1920s, the way shareholder meetings typically worked was management of a corporation would write to all the shareholders and say, please give us the right to vote your shares at the annual meeting. Shareholders would sign a proxy and say, sure. Then no one would actually be at the meeting, or almost no one, except for the managers who had the right to represent and vote the shares at the meetings. In the 1930s, the Securities Acts imposed some requirements on proxies. In particular, corporate management was required to tell shareholders how their proxies were going to be voted. But that was about it. But then came the idea of the shareholder proposal. Starting in the 1930s, a few, to be blunt, a few bored, wealthy individuals decided to start attending shareholder meetings because, well, the individual I'm thinking about, a guy named Lewis Gilbert, one might say he didn't have anything better to do. And so he would go to the annual meeting. He inherited a bunch of money, so he owned a few shares in a lot of corporations. He would offer his thoughts from the floor because you still could go to the shareholder meeting and speak to management there. Management would ignore what Lewis Gilbert said and brush him off, and he was really quite crushed. He thought he had all kinds of great ideas for how corporations should be run better. In 1939, something very clever occurred to him. Remember, the Securities Act said that management had to disclose some information to shareholders, including how management would vote their proxies. Generally, if the only issue was electing directors, it wasn't a big deal. But Gilbert realized if he told management in advance of the annual meeting that he was going to make a proposal from the floor, for instance, change how you elect directors, change how you choose auditors, he argued that management had to tell all of the shareholders about his proposed, the proposal he was going to make when it asked for their proxies. And the SEC agreed with this and adopted a rule in 1942. What did this let one activist shareholder do? If the activist shareholder wrote to the corporation in advance and said, I'm going to have a proposal at the meeting, corporate management had to tell every shareholder about that shareholder proposal in the proxy statement that the corporation paid for. Suddenly, small shareholders had been given a megaphone. Back to Bayard Rustin and James Peck. In 1948, they went to the Greyhound annual meeting held in Wilmington, Delaware. Why? Of course, to protest the fact that Greyhound had not desegregated its buses, and also to protest the fact that Greyhound policy actually said even interstate buses had to be segregated. Remember, it was illegal for the state to mandate segregation of those buses, not necessarily for Greyhound. By the way, I'm going to jump ahead for a second because here is a photo of the 1948 meeting on the left. That is James Peck. And good radicals that they are, as soon as the meeting finished, they walked outside, put on signboards and protested the meeting of Greyhound. But there we go. So Peck and Rustin show up in 1948. And I think their attempt to turn the shareholder meeting into a site of civil rights protest is striking because it shows us the interaction of corporation law and the ethos they had absorbed at CORE and the Fellowship of Reconciliation. One thing that initially puzzled me was James Peck was a wealthy heir. He had a trust fund. Bayard Rustin had no money at all. He was living on a stipend from a radical nonprofit. Why did they both buy shares and go to the Greyhound meeting? I think the answer lies, and I'll admit this is a bit speculative, in the ethos of CORE. They were in their very nature interracial and trying to upend racial hierarchies. To have Peck be the only one to go perhaps would have reinforced a racial hierarchy. So both men attended the meeting. Actually, the 1948 meeting, Rustin couldn't attend. So the African-American gentleman on the left is actually named Lewis Redding, who went in his place, who was head of the Wilmington NAACP, and later on was involved with Brown v. Board and the litigation in the litigation in Delaware that led to that. So both Peck and Rustin buy shares and want to go to the annual meeting. But here's where corporation law takes its place or also helped shape the protests they planned. Why did they choose Greyhound? Something I didn't mention. All the arrests that took place on the journey of reconciliation were on Trailways buses. Greyhound was still all in favor of segregation, but Greyhound knew of bad publicity when it saw it, and Greyhound was a national corporation which was able to order local bus drivers, basically said, when the journey gets on, don't have these men arrested, leave them alone. But if Peck and Rustin wanted to use shareholder power to challenge segregation in bus lines, they had to target Greyhound. Trailways wasn't a public corporation. Trailways was a brand name for a bunch of independently owned small bus lines that just happened to operate operate as a network. But there were no Trailways shares to buy, no Trailways annual meeting to attend. So Greyhound was the corporation they had to target. So they show up again, Peck shows up in 1948. Rustin wanted to go as well, but was somewhere else. They don't go back and by the way, what happens? They get to the meeting. They say, we want to make a proposal from the floor. The secretary of Greyhound says, I'm very sorry, you can't do that because we didn't have advance notice. And they're not allowed to speak. They don't go back in 1949 because, as best I can tell, Rustin was serving a term on a chain gang in North Carolina at the time. But at some point, they learned about the shareholder proposal mechanism. So in 1949, they wrote to Greyhound and said, we want a proposal to be included in the proxy that you, corporate management, are sending all the shareholders. And our proposal says, end Jim Crow seating on bus lines. By the way, the spelling of Jim Crow is not a typo. Apparently, that was a fairly common spelling in the 1940s and 50s. They make a second really interesting argument in their shareholder proposal. They are, although neither of them had a knowledge of corporation law, they were extraordinarily intelligent individuals. So they said, it's not just that we oppose segregation. We think segregation harms Greyhound shareholders. And we want Greyhound to end it because the company is now having to pay settlements to individuals who've been illegally discriminated against. You can guess what Greyhound did. Greyhound said, we're not going to print this. But if Greyhound or any other company chose not to print a shareholder proposal, it had to notify the SEC and get a response from an SEC staff attorney in what is now called the no action process. You can get something called a no action letter. The SEC had, it is true, said that you can't have a shareholder proposal that just targets general social or political issues. In 1945, a shareholder tried to have a proposal which said, get rid of the federal income tax. And the corporation said, well, that's nothing we can do. And the SEC said, yeah, you don't have to print that shareholder proposal. So Greyhound wrote the SEC once it got the proposal from Peck and Rustin and said, we want to exclude this because it's a general social problem. The SEC said you can exclude their proposal this year because it was untimely. Basically, Greyhound dragged Peck and Rustin out long enough until Peck and Rustin were no longer had enough time before the meeting. But in 1950, it appears the SEC attorney, staff attorney assigned to this, also said that Peck and Rustin's proposal was a proper topic for a shareholder proposal, which meant if they met the timeline the next year, they could have it included in Greyhound's proxy statement. Then the SEC changed its mind. When Peck and Rustin went back in the fall of 1950 and said, we'd like to include this proposal, the SEC attorney, the SEC attorney at the end of 1950, that earlier quote is in the beginning of 1950, said the Greyhound doesn't have to include the proposal in its proxy statement because it addresses what is essentially a general political, social, or economic problem. So Peck files suit. Rustin does not, interestingly enough, and I don't know why. So the case comes up as Peck v. Greyhound. By the way, the fact that Rustin wasn't involved might be one reason why earlier scholars didn't pick up on this case. James Peck isn't well known, but I'd like to think that some corporate law scholar, if they'd seen this case, would have said, wow, what is Bayard Rustin doing involved in a shareholder lawsuit, and pursued the topic. So Peck sues in federal court, the Southern District of New York. He loses. But the reason the judge refused to require Greyhound to include his proposal in Greyhound's proxy was a matter of administrative law. He said, you didn't appeal the staff attorney's ruling to the entire 5-member commission. Could Peck have won a later case? Maybe. There were at least one former SEC attorney at the time who argued that Peck's proposal, in fact, since it really dealt with the policy Greyhound had adopted, and it pointed to specific harms being done to Greyhound shareholders, might well have been the kind of topic that should have been included in Greyhound's proxy. I'm jumping over a couple of points here because here's the important thing. In 1951, it appeared very likely that Peck would sue again or go against Greyhound once more and try to get the proposal included. So what did the SEC do? The SEC changed the securities laws. Specifically, the SEC changed its rules governing what proposals can be included. Before January 1952, the SEC rule said that corporations could exclude proposals promoting general economic, political, social, or similar causes. In 1952, they changed the language of the rule to say corporations can exclude proposals promoting racial causes. In other words, because the SEC had determined that racial issues were not proper subjects for shareholder proposals, they in fact wrote race into the US securities laws. And Arthur, I'm going to apologize because I have a feeling I should be using the term regs rather than laws when I talk here. But I think the point holds up pretty well. The rule, while there were some protests about it, by the way, I wrote this paper during COVID. The National Archives have been closed for the last 2 years. So I've been unable to look at the original SEC documents and have had to sort of triangulate and use quotations other individuals have made of the documents relating to this case. But after the end of 1952, racial proposals were per se not allowed under the shareholder proposal rule. No civil rights proposals read broadly were offered again until the Vietnam era when, and I say civil rights, but I guess the Vietnam shareholder proposals were really against munitions manufacturers. No shareholder proposal touching on civil rights was offered over the next 2 decades, the decades of profound social change in the United States. The SEC had blocked this entire avenue of protest. This language was not removed from the regulations until 1977, July 7th, 1977, 3 days after the bicentennial. So concluding, I look forward to your questions and comments, but I think this paper is important, as I said, first of all, because as I said earlier, because it is an attempt to link together the history of 2 areas that we think of as separated, corporation law and the civil rights movement. I think it is also important because it tells us an important path that was not taken. Since the 1970s changes, shareholder proposals on social issues have become an important aspect of shareholder activism. But for over 2 decades, they were completely banned by SEC rules. And when we ask, it's always tough to say whether an event that didn't occur had significance. But I would like to think there is some significance to the fact that an agency of the federal government blocked at the time what has become an important avenue for social protest. And with that, I will stop sharing my screen and look forward to questions.